My name is Jeff Morgan, and I am going to talk about a case that is actually docketed before the Supreme Court of the United States, Ryan Pankow v. Laura Pankow, on petition for a writ of certiorari to the Superior Court of Pennsylvania. Now, this case happens to deal specifically with the issue of unilateral no-fault divorce. Two questions are presented before the court. Number one is whether Section 33.01D of the Pennsylvania Divorce Code, commonly known as unilateral no-fault divorce, is a viewpoint-based statute in violation of the Establishment Clause, and also whether 33.01D of the Pennsylvania Divorce Code is contrary to public policy, failing to serve a public purpose in violation of Pennsylvania's Constitution, Article 3, Section 32. Now, I know Ryan. Ryan is a friend of mine. I've talked with him in person. We occasionally talk even still, but I've met him in person, interviewed him, and I also know the person who wrote this petition to the Supreme Court. I think he did a marvelous job presenting the case that needs to be heard in front of the Supreme Court. When we talk about unilateral no-fault divorce, what we forget is that sometimes there are constitutional issues that are involved. So, for example, in this case, what's being argued is that unilateral no-fault divorce, and basically when I say unilateral no-fault divorce, all it means is that one person gets to impose divorce upon a spouse for any reason, for no reason, that can make up a reason. Whatever the petitioner or the plaintiff says goes. That is what unilateral mean. I get to impose my will upon you. I get to impose my wishes upon you, my husband or my wife. And really what it comes down to is that you don't have to allege anything. No fault has to be alleged. It just becomes a viewpoint. I think the marriage is irretrievable. Those are the magic words. If you think that the marriage has irreconcilable differences, that it's irretrievable, bam, it's kind of like abracadabra, you will get the divorce. But what is noticeably absent in this type of a situation is that no conduct is being regulated by the statute. It is merely a viewpoint statute. And accordingly, it is in violation of the First Amendment, the Establishment Clause, which forbids the states and the federal government from establishing a viewpoint dealing perhaps with religion or ideology. It also is a violation of the 14th Amendment of the United States Constitution. It's a violation of the Pennsylvania Constitution, Article 3, Section 32, and also the Pennsylvania Divorce Code, as mentioned earlier. Now, the whole brief here goes into a little bit of the background as far as how the divorce was granted, and basically what had happened was is that Laura stated that the marriage had an irretrievable breakdown. Laura asserted this, and Laura was able to get a divorce on that basis. Now, Ryan said there is nothing irretrievable about the marriage, and it was completely salvageable, and he did not want the divorce. But Laura, by force of will, was able to force a divorce upon him, force him to undergo this legal process, or this quasi-legal process, because the reality is that divorce itself, the way that it's done with unilateral no-fault divorce, it is a sham lawsuit. It has a predetermined outcome. The petitioner or the plaintiff will win 100% of the time. How do I define winning? He or she gets a divorce. The divorce is never denied. Without exception, 100% of the time, the petitioner gets a divorce. So it is a lawsuit, a fake lawsuit, and which has legal trappings, the appearance of something legal taking place, but the respondent or the defendant has absolutely no process. There is nothing that person can do either to bar the lawsuit or to win the lawsuit. In fact, what happened then instead is that divorce is granted, and in this instance again, what happened is that the divorce was granted. It was forced upon Ryan. He had no legal defense, and it was forced by the state of Pennsylvania upon him. Irretrievable breakdown, it's it's a very subjective viewpoint, and the problem is this: the state always sides with the person who alleges irretrievable breakdown and forces a divorce, and it does cause real damage and real pain and irreparable damage to multiple parties. So a permanent dissolution in the party's legal status has resulted from this proceeding. Thus, real and irreparable damage has occurred in the lives of the two parties, as well as their children's lives, extended family, and the broader community. The consequences of this forced action of divorce by the Commonwealth of Pennsylvania will last a lifetime. And what is going on here is, again, that the state is actually forcing this divorce. It is very reminiscent of what Vladimir Lenin did in Bolshevik Russia. When he wanted to impose communism on Russia, what he did, one of the first things he did was create the idea of unilateral no fault divorce. And it did two things. It took marriage out from under the jurisdiction of the church, and it said marriage is now a product of the state. The state can regulate it. The second thing is, so basically it weakened the church. But the second thing is this, it also weakened family structure. Because when you have one person who can file for divorce for any reason, for no reason, they can make up a reason. It does not make a difference. Today I woke up and I said, well, I just don't want to be married anymore. I can get a divorce. That leads to the destruction of the family. The destruction of the family, as Vladimir Lenin said, if you want to destroy society, destroy the family. He knew that strong families were the number one defense against communism that he was seeking to impose in Bolshevik Russia. By this one action of unilateral no-fault divorce, taking marriage from the jurisdiction of the church and making it an action that nobody could ever defend against, it weakened the church, and it also destroyed the family. Now, in our system of law, supposedly, laws are supposed to regulate conduct. So, for example, if the speed limit says 45 and I'm driving 75, I can be pulled over and given a ticket because my conduct of driving 30 miles over the speed limit is the issue. It is my conduct. But if, for example, in COVID, when the government says you need to wear a mask because we say so, this is what the CDC says and everything else. And my viewpoint, it says that I don't believe it. I believe that masks are stupid. I believe that masks do nothing to really stop the spread of COVID, or very, very little. It may do something, but it may cause other damage as well. That's okay that I hold a contrary belief. The state cannot arrest me, cannot fine me, cannot put me in jail, cannot destroy me because I hold a different viewpoint. And what is happening with the issue of marriage here is that when marriage now becomes an issue of viewpoint, I say that marriage is irreconcilable. The courts are involved in something that they're not allowed to be involved in. They are establishing a specific viewpoint. And Ryan's marriage was broken basically because of the idea of irretrievable differences. One of the things that we don't talk about a lot with the idea of unilateral no-fault divorce is that the judge himself or herself is not acting in a judicial manner, but acting in a ministerial manner. The judge is not acting judicially. The judge is pretending to act judicially under the color of law, but the judge actually is not doing so. There really is nothing that the judge is exercising any discretion. There is a predetermined outcome. When a person files for divorce based on irreconcilable differences or irretrievable marriage or whatever it may be, that is a viewpoint. That viewpoint would automatically be asserted and held. The division of assets is immaterial because the action of dividing the assets, destroying the marriage, destroying that which should be protected by society, that itself is what the problem is. And the judge, just one judge told me, Judge Brett Hall of the 382nd District Court in Rockwall, Texas, he said specifically, I don't have any discretion. I have to grant a divorce. Well, the judge is not acting in a judicial manner. He's acting in a ministerial or an executive manner. That implicates the separation of powers doctrine. And it also is stating this, that a judge is depriving a person of meaningful due process. Meaningful due process means one of two things. Number one, it can mean that the lawsuit can be barred completely because there is no lawsuit. Or number two, the respondent or the defendant to a lawsuit actually has a chance of winning, of showing that the lawsuit is frivolous and maintaining his or her rights during it. Due process is completely denied during unilateral no-fault divorce. And when we look at what happens with viewpoint discrimination, so we know that, for example, Rape is a conduct. It is an action. If one person rapes another person, that is something that is punishable by the state. But for somebody to go to the court and said, well, he raped me in his mind, I don't know whether that person did or didn't, but even if that person did rape another person in his mind, that is not something that is punishable. That is something that took place in the mind. Whether it be lust, whether it be covetousness, whatever it may be, there's many things that people can be tempted to do if they do not act on their thoughts. There is no conduct which is worthy of imprisonment. We do not put people in prison because of their fantasies, however bad or perverse they may be. It's the actions that we actually punish, not the viewpoint. So the Pennsylvania Divorce Code statute here, it violates the Establishment Clause. The Establishment Clause actually forbids legislation that endorses beliefs, opinions, and viewpoints held by private individuals. And again, if a person alleges irreconcilable differences, that is his or her opinion. It is his or her belief. It is his or her viewpoint. It may be his or her desire. And the person who's the party to the marriage can do nothing to stop it, even if he or she believes just the other way around. So if you look at the case right here, how was the marriage irretrievably broken? Simply because Laura said it was. Laura was Ryan's wife at the time. That's it. She said the marriage is irretrievably broken, and that was the only cause for legal action. The issue, though, is not just a Pennsylvania issue. This is actually an issue that affects everybody in the United States. And the reason I say this is because all of the states have some type of provision for no-fault divorce, unilateral divorce. Now, there are a couple of states that I believe no-fault divorce has to be by mutual consent. I believe it's Mississippi and South Dakota, and I'm not sure exactly how those areas work there. But the reality, nevertheless, is that no-fault divorce, for all intents and purposes, is the law of the land, and it's a viewpoint statute. Now, according to Section 3301, the language of the divorce statute reads, the court may grant a divorce where a complaint has been filed alleging that the marriage is irretrievably broken. Now, again, irretrievably broken is a subjective opinions, and the courts are not allowed to rule on opinions. So if they're ruling on an opinion, they really should have no jurisdiction over the lawsuit to begin with. And by the way, divorce is contrary to the public policy of many states. When you look at any type of judicial proceedings that take place under the no-fault divorce statute, they're based on legal fiction. And that's all you can say about it. It is a sham lawsuit. There's really no legal action that even should be allowed. What is also argued here is that with the state of Pennsylvania, and again, this goes through almost every state in our country, only one type of opinion is acceptable by the state. And specifically here to Pennsylvania, the only acceptable opinion is that the marriage is irretrievable. So the court always, without exception, 100% of the time, sides with the person who wants a divorce. A person who says, wait a minute, I think our marriage is not irretrievably broken, whatever, that this should not even be a cause of action for divorce, but that person has absolutely no protection and will always lose. And by losing, what I mean is that the divorce will be granted against his or her will. His or her family will be destroyed. Some people may want to say, well, you don't want the person who wants a divorce to live in a prison or do you? And to which I would say, if the person wants to leave, you really can't stop that person from leaving, but a person should not be able to leave the marital estate and plunder the marital assets, and the state certainly should be upholding marriage rather than incentivizing divorce. As it is right now with unilateral no-fault divorce, marriage has no legal protection. No legal protection, no obligations or rights or anything are actually established in marriage. Marriage is really just a registered cohabitation, which is registered with the state, and it lasts until one person says it doesn't last anymore. So ironically, the Pennsylvania courts have affirmed that trial courts are not entitled to grant divorces based solely on an individual's viewpoint. So Pennsylvania has failed to adhere to its own reasoning by granting a divorce solely upon the respondent's viewpoint. Actually, this should have been the petitioner or the plaintiff's viewpoint. I think this is just incorrect right here. Because once again, once a person alleges divorce for whatever reason, that person will always win. There is no defense against that. And so, again, when you look at marriage, then usually what we think is when we get married, we have rights. And in fact, if you look at many of the family codes, one of the first things they talk about are property rights and stuff like that. Rights are established in marriage. Rights to property, exercise religious obligations in a family context, the protection, maintenance, and education of children. All of those things can be wiped away by the decision of a so-called judge who was acting in a non-judicial manner. And this is what our legislators have approved is going to be okay, that marriage can be destroyed based on one person's whim. However, the reality is that marriage is a legal status. When you get married in most states, and maybe all of the states, you have to apply for a marriage license. You have to go through a certain process, and your marital status changes from whether you're single, whether you're divorced. You change whatever that marital status is from that to married. And with that married legal status, you also have some rights and benefits. So, for example, married couples have often different tax benefits, and that's one of the big reasons why same-sex people, homosexuals, lesbians, wanted to get married so that they could share in that. They felt it was discriminatory that they not be able to participate in some of the tax benefits associated with marriage, or some of the health care benefits that one partner could have and pass it on to his or her significant other, spouse, whatever you want to call it. But again, when we talk about marriage, marriage is a legal status. However, unilateral no-fault divorce actually makes it an illusory legal status. It is a fake legal status. And the reason I say this is because the legal status exists only as long as one person wants it to. There are really no legal obligations anymore with marriage, and this is how the states have destroyed marriage. So Section 3301 in particular does not create a primary duty devolving upon the defendant, nor does it contemplate a general delict or wrong done by the defendant. And this was evident in the divorce decree because the divorce decree was unable to demonstrate how Ryan had failed to meet his legal obligations pursuant to the statutory cause of action. According to the trial court, he was not at fault for anything, but nevertheless, the judge granted a divorce. To grant a divorce in defiance of these constitutional implications is unlawful because, though the agent is cloaked with judicial identity, they lack judicial capacity and so thusly act in the absence of subject matter jurisdiction. Legislative powers of the government reach actions only, not opinions. The state can regulate conduct. The state cannot regulate belief, whether it's religious belief or whether it's somebody's belief that my marriage is irretrievable. The state has nothing to do with that. It is forbidden from targeting or sponsoring particular viewpoints of its residents. Coming further down, the burden of proof actually rests with the Commonwealth of Pennsylvania as to whether 3301 serves a public purpose that targets actions as distinguished from viewpoint. And this is a burden that the state has to overcome. The respondent, in this case Ryan, this is not upon him. The state has to give proof as to how divorce serves a public viewpoint. A state may not, consistent with the obligations imposed upon it by the Due Process Clause of the 14th Amendment, preempt the right to dissolve this legal relationship of marriage without affording all citizens access to the means it has prescribed for so doing. Anybody who gets married, they get married at least initially because they want some type of societal recognition, they want legal status, they want the church to recognize them, whatever the case is. They know that there is a legal status involved. They know that this is supposed to be lasting a lifetime. It is very rare that you hear a vow that is said, we will be married for the next 5 years, after that which time we will divorce, and then we will move on to a new life. Most people still say, even the non-religious, we are getting married till death do us part. That is what they utter, the words that are uttered. And if it's in a Christian church, if it's some type of religious ceremony, it's being uttered before God in front of the presence of many witnesses. And if it's just two people that are in a non-religious ceremony, and if they still utter the same thing, that's what they have committed to. On a contractual basis, for Christians, Christians believe that marriage is more than a contract. It's actually a covenant. It's a covenant with God. This is a vow to God. If you're not a Christian, you might just say, well, it's just a contract that we're making. And maybe, it's a contract that we wish to break. Maybe if you want to say, we're going to be married until our love dissolves or something like that, that's fine. But the state has the presumption that the marriage is supposed to last. So the state, by granting divorce on demand, divorce for any reason, for no reason, forced divorce, the state is actually violating its very purpose in establishing marriage. It is actually engaged in fraud, in my opinion. So some people say, well, marriage is just, between two people, and actually it's not. Marriage is not just a private interest, it is a public good, over which the law presides in a manner not known in other department. So therefore, accordingly, strict scrutiny needs to be applied to the state's actions. Again, this is not applied to Ryan, it applies to the state. For the state to take away his marriage based on viewpoint only, the state is actually violating Ryan's fundamental rights to marriage, and also violating public interest, and also violating its own public policy. So the state's actions need to be scrutinized to make sure that what they are doing is constitutional. The burden of proof is upon the state to assert why its actions are actually narrowly tailored, and why they serve this compelling state interest. Apart from this, the state and the courts are acting in a completely tyrannical and dictatorial manner. If the state invades a fundamental right, it is subject to strict scrutiny. And when fundamental interests such as marriage are involved, the state bears the burden to show why it is taking the action that it is. So I will talk about this more. I will continue this in the next video, talk a little bit more about the case, and specifically as it applies to Panko v. Panko in the Supreme Court of the United States. Thank you.